so I think we might get started. I want to start by welcoming you to this panel that I am just derangedly excited to be moderating. And I'm going to start by asking you, the powers that be want me to tell you that as this is being recorded, please turn off your phones or mute them. And there's going to be lots of time for questions at the end because I'm sure you have lots of questions, but I'm going to just caution you in advance to think of your questions as questions, and they should come in question form. I'm really honored to be moderating this panel. This is kind of puts the who in who's who on this issue, and it's really a thrill to be here. And I just want to point out that I'm probably the best positioned person to moderate this panel, only because I've taken absolutely every single irreconcilable position on this issue that there is. I have written in a very short amount of time both that this is a fundamental right and should be tackled by the federal government, but also that states should probably regulate marriage. And I've taken the position that incrementalism is good, but also bold sweeping action is good. And so if you try to sort of look back and find any pattern whatsoever in my thinking, you will say, there's a person with strong opinions and no actual knowledge. So I'm hoping that's going to change this morning. And I really am thrilled to introduce you to this panel. On my far right is Dale Carpenter. I'm just going to also say you have lengthy bios. I'm not going to waste your time talking about their bios, so I'm going to give you very compressed bios with the promise on your part that you will read the bios in your packages. On my far right is Professor Dale Carpenter, who comes to us from the University of Minnesota Law School, where he teaches First Amendment, constitutional law, sex orientation, and the law. He has a BA from Yale, a JD from the University of Chicago. He clerked for Edith Jones on the Fifth Circuit and is the author of Flagrant Conduct, which is a book that you must all read. It's the story of Lawrence versus Texas. And he is involved in Minnesotans United, which is the equality movement in Minnesota. To my direct right is Suzanne Goldberg. She comes from Columbia Law School, where she founds and directs the Sexuality and Gender Law Clinic. She has been a participant in marriage equality litigation for a very long time, and she has been involved in Perry and other cases we're going to talk about today, and has written extensively on marriage equality, and spent almost 10 years litigating at Lambda Legal on the cases we're going to talk about today. To my far left, Stacy Long, the Director of Public Policy and Government Affairs at the National Gay and Lesbian Task Force, the oldest national organization advocating for gay rights and lesbian, gay, and bisexual rights. And her work extends beyond the traditional notions of what of gay issues and crosses over into issues that have to do with pay equity, reproductive rights, and immigration reform. And finally, to my immediate left is Paul Smith, partner at Jenner and Block in Washington, D.C. He chairs the firm's Appellate and Supreme Court Practice Committee. He's argued 14 cases in the U.S. Supreme Court. I have mocked him on more than one occasion.
Mocked or mooted?
Mocked. And he most recently argued the violent video games case and also Lawrence. He was in 2010, the National Law Journal named him one of the 40 most influential lawyers of the past decade, and in the same year he was awarded the Thurgood Marshall Award for promoting civil rights from the ABA section on individual rights and liberty. So I want to welcome these four really, really impressive panelists, and I look forward to what they have to say. Just as a brief introductory remark, I just want to point out that which we all know, which is that's been an extraordinary few years for marriage equality. President Obama recently came out in support of gay marriage, and recent polls are showing that amazingly as many as 53% of Americans favor legalizing same-sex marriages compared to just 36% 6 years ago. So the change has been stunning and dramatic and quick. Half of the country approves of President Obama's statement that he supported gay marriage. And 71% of the country in the most recent polls I have seen say that they have, in fact, a gay friend or acquaintance or family member, and they have come round on this issue. In our very, very brief time, compressed amount of time that we're talking about, Don't Ask, Don't Tell has been repealed. The Obama administration has flipped its position on defending DOMA, and 6 states and DC allow gay marriage. So the question for us is, we've got some states that are, by way of referendum, chipping away at the right to gay marriage, and we have courts that are going the other way. In just very, very recent weeks, we've got federal courts in Massachusetts, New York, and California declaring DOMA, the Defense of Marriage Act, unconstitutional. And we have the Ninth Circuit in February striking down Prop 8, which did away with same-sex marriage in that state. And just recently, as you all know, the Ninth Circuit declined to take that en banc, so this issue is now presumably going to the Supreme Court. So I want to start, I think, by asking Professor Carpenter, who's got a long view, a historic view of what's happened in the last few decades, to just sort of walk us through the changes in this litigation from the 90s, the 2000s, till today. Thank you.
So what I thought I would do is take a look especially at the Perry litigation through the prism of some of the other landmark Supreme Court decisions that we've seen in the past 50 to 60 years, especially in the area of gay rights. The Perry litigation, as you know, is a challenge to California's Proposition 8, although some of the arguments in the litigation present a broader challenge than simply to Proposition 8, but indeed to all marriage laws, and suggest that they are unconstitutional on due process or equal protection grounds. To see where that litigation is in comparison historically to some other litigation, think, for example, of what led to the court's decision in Lawrence versus Texas. Lawrence versus Texas was the culmination of about 50 or 60 years of activism and of change in the area of respecting the private intimacy choices of adults. As of the year 1960, all 50 states in the United States had some version of a so-called sodomy law that prohibited some sex acts between both same-sex and opposite-sex partners. Through a process of legislative action and judicial challenge, that number dwindled over the next 25 years or so from all 50 states to, by 1986, I think 24 states. That was the year that the Supreme Court decided Bowers versus Hardwick, when it decided that there was no fundamental right, as the court termed it, to engage in homosexual sodomy. That number had dwindled further by 1998 through continued state-by-state legislative push and mostly judicial push in the late 80s and into the 90s to about 16 states that still had such laws. And that was the year that John Lawrence and Tyrone Garner were arrested in John Lawrence's home in East Harris County, Texas, allegedly for engaging in an act that violated the Texas homosexual conduct law. It's at that point that gay rights litigants, including especially Lambda Legal, which headed up the challenge to the Texas homosexual conduct law, decided that the time was ripe, with 16 or so states left at that point and a couple of challenges ongoing in the other states. The time was ripe to take another crack at the Supreme Court. That ultimately, 5 years later, ended up in the Supreme Court in Lawrence versus Texas, by which time the number of states with sodomy laws had dwindled to 13, of which 4 applied to same-sex only conduct. The remainder, on their face at least, applied to both. In Loving versus Virginia, by the time the Supreme Court decided that case, the case that struck down miscegenation laws across the country, there were 16 states that still forbade miscegenation, and the Supreme Court struck down those laws. In Brown, there had been a continual erosion of racial segregation, bit by bit, piece by piece, in litigation and legislatively around the country, so that segregation, racial segregation, was more and more confined to mostly to a region of the country. All of that litigation was the product of a lot of painstaking work by activists, by lawyers, with careful strategy designed to pick away and erode the foundation for these laws. When they came to write their briefs in Lawrence versus Texas, Lambda Legal, including Paul Smith and others at Jenner and Block who were involved in writing the briefs, decided on a theme for their litigation. And their theme before the Supreme Court was going to be this, that in striking down the Texas homosexual conduct law, the court would not be leading the country down a new, uncharted path of constitutional right or sexual license, but instead the Supreme Court would be following the rest of the country. For most of the country, this issue was already dead and gone. 37 states didn't even have such laws enforceable, and of the remainder who did, the laws were rarely enforced against private sexual conduct. And there was not much grief in seeing them go, except by a few organized groups. So their theme was following, not leading. The court would be following, not leading the country. And that was a very successful strategy for them. The Supreme Court issued the opinion that it did, which may be the foundation for progress in the future. So where in this story of careful, painstaking litigation, state by state, year by year, law by law, does the Perry litigation stand? In 2009, at the time that the Perry litigation was filed, there were still at that time, I think, 46 states, somewhere in that neighborhood, that did not recognize same-sex marriages. We are down to 44 now, with New York having been added over the past year, an important state. But that's still 44 states where same-sex marriages are not being performed. 2 of those are on the ballot this year where legislatures have approved, but voters have to have a first pass at it, and we'll see what happens in those states. It's Maryland and Washington State. So the Perry litigation takes on a much broader swath of the country and many more state laws than did the careful challenge in Lawrence versus Texas. This is not to say that it is a loser. The Supreme Court is not simply a polling agency that polls the states or looks at national polls and then decides how it's going to make a decision or whether it's going to strike down a law. But it is instructive that I cannot think of a time in the past 50 years when the Supreme Court has struck down the laws of as many as 40 or 50 states since Roe versus Wade, which some people on the court, including Justice Ginsburg, have said was too much too soon and produced a backlash that was not helpful to abortion rights in the country. Whether you agree with her or not about that, and I think there's some grounds to disagree with that view, it is telling that a justice who's otherwise affiliated with a more liberal view of the Constitution holds that view of matters. So this litigation presents potentially a much larger challenge, at least if we take it in the form that Judge Walker left it, where if the Supreme Court adopts the analysis of Judge Walker, it would be taking on the laws of all 50 states, 44 states. If it takes on the logic of Judge Reinhardt on the Ninth Circuit, on the other hand, it is a decision that would be a ticket good for this ride only. And I think we could I think we can understand Judge Reinhart's opinion as an effort to save the Perry litigation from a potentially disastrous result in the Supreme Court. And one of the interesting things to watch as this case is, assuming it's taken, as this case is decided, is how the court will decide to view the claims being made and how aggressive it will be, if it is at all aggressive on this issue. Thank you.
So, Professor Carpenter, you told the LA Times you thought, for I think the reasons you've just provided, that you thought the court may actually not take the Prop 8 case. And then Suzanne Goldberg said, I think in the same week, that you'd be shocked if the court sidestepped both. So I wonder if you can now flesh out the other side of the story, which is help us understand there are these two cases. They're in a foot race to the court. They raise related but slightly different issues. And I wonder if you could just help us understand what the two cases involve and which one we should be rooting for.
Well, the part that didn't get quoted in that, oops, is that working okay? Is that okay? Better? The part that didn't get quoted in that article was that I thought the challenges to the Federal Defense of Marriage Act were the better cases for the court to take for a variety of reasons that I'll get to in a minute. But first, I think we have to spend just a moment putting in perspective where we are. Is this okay now? Feels like I'm getting a big buzz. Okay. Which is that if we were here 6 years ago on this same panel, the same discussion, none of us would be smiling at all, because you may or may not remember, but that was the summer of just completely depressing, bad news, 1 week after the next, where we lost in litigation and we lost legislatively in every state where a question about marriage rights for same-sex couples came up. And it was relentless. Sort of Georgia, New York, the 8th Circuit, Washington State, California, and the New Jersey Supreme Court. We lost and lost and lost. And so it's pretty remarkable, actually, to think that 6 years later, we're having a similar rapid-fire slew of opinions and legislative action, and most of it we're winning. Now, of course, we're also at a moment where we could see this, be back here in a year and have all of these wins solidified. We could be back here in a year and in a very different position, right, where legislatively some of the gains we've made have been taken back by voters in initiative processes, and likewise potentially by the Supreme Court. But let me answer or respond at least to your question in part. So Dale just laid out the key question in the Perry case, and there are two ways to think about it, but I'll just set it out again. So the central question in the challenge to Prop 8 is really the core question of marriage equality, right? Does the Constitution forbid states from blocking same-sex couples from marrying, right? And the arguments there are based on the Equal Protection Clause and the Due Process Clause, very standard arguments, right? That the state cannot draw a line, put same-sex couples on one side, different-sex couples on the other, consistent with for purposes of marriage, consistent with the Constitution. The question in the DOMA cases is very different, right? And there are, at this point, I think we're at about 10 cases, not quite, almost 10 DOMA cases that have been brought challenging a variety of ways in which the federal government is refusing to recognize existing marriages of same-sex couples, right? So the DOMA cases are about couples who are presenting themselves to the United States government saying, we have been married by a state. The state recognizes our marriage. Federal government, you need to recognize our marriage for purposes of tax benefit, or tax benefits, I guess, immigration rights, and a host of other ways in which the federal government recognizes marriages. You may remember that the General Accountability Office, it's now called, right? Or Government Accountability Office, the GAO, did a report early on in connection with DOMA and identified 1,000+ ways in which the federal government privileges marriages over other forms of family, and that number has only grown. So that's the question in the DOMA cases. why do many people say that it would be better for the DOMA cases to go to the Supreme Court than for Perry, which again puts that the sort of core can states deny marriage to same-sex couples question front and center? A couple of reasons, and I don't want to go too deeply into the doctrine, so let me just stay in the conceptual, right, at least for now. And the big picture point, I think, is that the states at issue in the DOMA cases, right, in the Defense of Marriage Act challenge cases, the couples are actually married. States have been willing to recognize those marriages. The federal government has not. That's an obvious tension, and it's a particularly appealing tension to frame up in some ways because the Supreme Court has made such a central point of the idea that the federal government should allow the states to do as they would do. And it's really not just sort of recent politics, right? There's a long line of Supreme Court precedent talking about the states being a laboratory and so forth. And to have the federal government sort of undercut that laboratory or really seal off the laboratory and say, oh, well, you have decided to recognize same-sex couples marriages in the name of equality, but we are going to pull the plug on that, is inconsistent with tradition, arguably, as well as with equal protection law and so forth. So one can say about the cases, I think, three things if we want to compare Perry and the DOMA cases. I mean, the DOMA cases, just to pick up on your, you had a ticket analogy, right? Ticket good for one ride only. So I was thinking about, right, the water parks that maybe some people will go to this summer, right? So the DOMA cases are like the low diving board, right? Because it's really, I mean, of course, for the U.S. Supreme Court to recognize marriages for same-sex couples, that's not nothing, right? I mean, in Lawrence, the court was careful to try to push aside in various ways the marriage question. At the same time as I think, for a variety of reasons, the arguments for marriage equality are very, very strong, very, I'm not a big traditionalist, but they are really quite traditional and consistent with the development of marriage over time. But nonetheless, it's the low dive because they are not, a decision from the Supreme Court striking down Section 3 of DOMA, which is the part about the federal government non-recognition, does not tell other states what to do, right? It doesn't force marriage, to use the words of our adversaries on these issues. It doesn't force marriage on states that don't want to recognize it. Perry, on the other hand, could be characterized as the high dive because it would force marriage on states that have declined to recognize marriage so far, because the court would, if it ruled for the plaintiffs in that case, be saying, in essence, states, you cannot, consistent with either the Equal Protection or the Due Process Clause, deny marriage rights. Now, Dale mentioned one other piece of another way to read the Perry case, and I'll just mention that in the last 15 seconds or so, which is that you could also see Perry as the kind of twisty slide next to the diving boards in the sense of exactly what Dale said, which is that the way the Ninth Circuit framed Proposition 8 and its decision to strike down Proposition 8 was not a major statement about states having to recognize marriage rights, but instead was a very particular statement about the problem in California where marriage rights had been granted and then taken away. And that, as many of you or all of you know, the court said, was really much closer to what the court described as being decided in Romer versus Evans, the Colorado anti-gay amendment case, which involved the repeal, in effect, and deprivation of sexual orientation, anti-discrimination protections for gay people. You know, do I want the court to go with us on the high dive and win? For sure. Do I think the better case for the court to take is off of the low dive and let the twisty slide just stay where it is? Yes.
Okay. I feel that everyone is running directly from ACS to a water park because of Suzanne's framing. So I want to turn to Stacy Long because you bring a really different perspective to this, and your work has really broadened out this conversation and talked about the way that the debate about marriage equality inflects on questions of race, faith communities, just the changing demographics in this country. So I wonder if you could, we're sort of in the wonky weeds here, and I wonder if you want to pull back and get us out of the wonky weeds into a sort of different look at the other moving parts in this conversation.
Happy to. So before I start, I just want to talk about the task force very briefly so that everyone knows who we are and what we do. We are, as you mentioned in the introductory remarks, an organization that focuses on the advocacy needs of LGBT people, so lesbian, gay, bisexual, and transgender people. And our lens through which we're looking at this work is a progressive agenda. And we are very, very proud of the work that we've done in partnership with social justice organizations and with progressive entities across the country. We are actually working at the federal level to lobby Congress to repeal DOMA, as well as mobilizing our grassroots to engage them on this fight at the federal level. What we're probably best known for, though, is our grassroots work, so our work on the ground. And as Professor Carpenter mentioned earlier, it is sort of in tandem. The social justice movement needs the activism that can then sort of partner with what happens in the courts. And so my remarks are going to focus on the broader social justice movement and some of the things that we've been seeing in popular culture, some of the things that we know to be true stumbling blocks within the movement, things that tend to distract, tend to give life to the opposition's efforts to retract and take away rights and roll things back in terms of progress. We're working at the state level in several different campaigns this year. This is a really exciting year looking towards November, and providing staff support, training, and finances to a number of different campaigns, Maine being one of them. And you know, it's one of those moments when, again, we have the minority population voting on the rights, or the public voting on the rights of the minority, and we haven't won yet any of those fights. And so what's the game changer? What do we need to be doing differently? What are the lessons that we've learned thus far? So with that said, we obviously are building upon all of the momentum that has been garnered following President Obama's endorsement of marriage equality. That was a huge game changer. It was a game changer not only because of his role as President of the United States, but also because it opened up the dialogue for several communities to be able to engage at the kitchen table, at the water cooler, at the happy hour, wherever the conversations were happening. It was different. It was, wow, President Obama endorsed marriage equality. What does that mean for me as a congregant in a particular faith-based place of worship? What does this mean for me as a teacher at a school? What does this mean for me as someone who is a hairdresser in a conservative community? And so I'm really, really looking forward to the next few months, despite knowing how much work is going to be involved in continuing to keep this dialogue and push it forward. I'm really, really looking forward to having those conversations, because I believe that through those conversations, through the changing of hearts and minds, that we have the endurance and the durability that outlasts administrations, presidential administrations, outlasts, or sort of we see that the courts are looking to where the public is in moments of time and making decisions based on that, even though it was a rare occurrence. I think it's very vital that we continue to make sure that the public understands the issues, A, knows that has correct information, and B, that at least with respect to the work that we do, it's important to us that our allies know what to say if they happen to be standing at the bus stop, sitting on the subway, overhearing something that is really just rhetoric and not based in truth, because we don't want those things to take hold. And so it's essential, I believe, that on the heels of the presidential endorsement of marriage equality, on the heels of the NAACP, the oldest national civil rights organization that represents, has been like at the forefront in terms of the civil rights movement, for them to take a position of endorsing marriage equality was hugely significant. And it really opened up a dialogue that needed to happen. I'm going to talk just really briefly about the faith-based African-American Christian-based tradition, because we saw with Prop 8 And then again, with Maryland, the fight for marriage equality in Maryland, the same running thread, the same theme that if black people are not for marriage, we won't be able to win. And there were some truly ugly episodes and exchanges that happened around Prop 8. Not so sure, marriage equality in Maryland battle, I think it was definitely a different context. But the research that we know, of course, is that it was not the black vote that had anything to do with Prop 8's passage. We know the numbers had more to do with generational position and more to do with, you know, a particular set of beliefs that was based on those demographics. Here in Maryland, we've had an opportunity to hit this head on by having conversations with the pastors at mega churches to challenge them on their don't ask, don't tell sort of position. So we know that LGBT people who look like me are in the pews, they're playing on the piano and the choir, they're, you know, part of the fabric intrinsic in the community and the neighborhood. And so why continue to take a position that is based in hate, that is based in taking away rights that we know you support in other contexts? So the thing that I was thinking about this morning as I was preparing to speak with all of you is that, you know, what is it about the African American community what is it about the cultural tenets of the African American community that is juxtaposed to this work, this fight that we're doing? And I think, like, what came to mind for me, at least what resonated for me personally, was this saying, don't put your business out in the street. You don't put your business out in the street. And that is a very protective posture. It's a very deeply rooted protective posture based on if people know something quote unquote bad about you, they will take it and do harm. So it's one of the reasons why there was this tension within the LGBT movement over the pressure that was being applied to the president to have him step forward, because really and truly, I believe there were probably conversations held where, what if we lose the black vote? Because if he takes this position, that's an Achilles heel, that's a vulnerability. What will the opposition do? And so I'm pleased that in the context of so many different settings, whether you're talking about mainstream publications like Ebony Magazine or Essence Magazine, there have been cover story articles, groundbreaking articles on Don't Ask, Don't Tell, on marriage equality, conversations between pastors who fall on both sides of the aisle in terms of their positions, and looking forward to the day when more young people are actively involved in talking to their grandparents about what they should do when they enter the polls with respect to LGBT equality, and specifically in this context, marriage equality.
So Paul Smith, he actually got the quote in the article that I guess they cut out of Suzanne's quote, because he actually, I do have him quoted somewhere saying that the federalism aspect of DOMA, the states' rights aspect of DOMA, makes it a much more a stronger case to go up to the Supreme Court. And so I thought we would, having started at Perry and then compared DOMA and Perry, I thought we could close the circle, Paul, and you could talk about DOMA and also the significance of the administration changing tack on DOMA.
Well, let me just agree, first of all, with Suzanne about the low dive metaphor. I think the reason why, after very, very careful consideration and a lot of years of soul searching after Lawrence, eventually there was a kind of a group decision by Lambda Legal and GLAD and ACLU to go after DOMA Section 3 rather than a federal constitutional right to marry is precisely because it's a smaller step. It doesn't tell any state it has to marry anyone, and instead it says, here are these people, they are married, they have these concrete needs like Social Security and health insurance, and you're denying it to them, and it doesn't serve any rational federal purpose whatsoever. It's simply out and out bigotry. And so the case has always been viewed as appealing along with the federalism aspect to it, and I guess we'll find out this year whether or not that judgment was right. I did want to talk a little bit about the president's decision to stop defending, which occurred after Judge Toro in Boston had held DOMA unconstitutional. The Obama administration in 2009 did defend it. And they were, this is an emerging theme where eventually executive officials don't want to defend these things. We saw the same phenomenon in Perry in California, where the Attorney General and the governor refused to defend Proposition 8, and the problem there was solved with an intervention by the proponents of the proposition. In the DOMA case, of course, it was solved by the intervention by the House leadership represented by Mr. Clement. And we saw this as recently as yesterday in Illinois, where the defendant in a new marriage case brought by Lambda Legal under state constitutional law, the county clerk of Cook County, represented by the state's attorney, there was an announcement that they're not going to defend the constitutionality of Illinois' failure to have equal marriage rights. And so there's a big question there of what kind of intervention you can have when there's never been a proponents of a proposition to be the interveners, but that remains to be seen. I did want to say, there have been a lot of criticism, obviously, from the right wing of the president's decision on DOMA, but it really was a very lawyerly decision. The reason why they were able to defend DOMA for a while in the First Circuit was because in the First Circuit there was precedent that they said meant that only rational basis scrutiny applies to sexual orientation discrimination. That was a don't ask, don't tell case from a few years ago that could be read that way. We argued otherwise. But they were able to get cover essentially and say, look, under rational basis scrutiny, which is applicable in the First Circuit, this is rational. And rational basis scrutiny, of course, is not as high as strict scrutiny. Then there were cases filed in New York in the Second Circuit where there was no such cover for them, and they were facing the obligation to file a brief saying that rational basis scrutiny applies even when, basically on its own merits, or saying that heightened scrutiny applies. And they came to the conclusion that they simply couldn't write a brief saying that under the factors that control this issue, when people are discriminated against based on their sexual orientation, it ought to be presumptively constitutional and ought to be only governed by rational basis. If you look at the factors that apply, which history of oppression, whether this is an innate characteristic, is this something that is relevant to your ability to contribute to society, et cetera, it's a pretty no-brainer issue, frankly, that there ought to be at least the kind of scrutiny that gender discrimination gets. And so they simply couldn't write either brief. And they ended up deciding they had to announce they weren't going to defend. And that obviously raises concerns. I mean, all of us on the progressive side can imagine things that we wouldn't want a conservative administration to refuse to defend, including, for example, a health care bill or something like that. But I think what you see here is it's much less serious a decision. It still should be taken very seriously, but less serious a decision than a refusal to enforce the statute. And I think the Obama administration has been very clear. We're going to not defend it, but we're going to enforce it. We're going to file appeals and cert petitions if necessary so that the courts can ultimately have a final resolution of the issue. And so it's been interesting to see how the sort of con law 1 issues of heightened scrutiny versus rational basis scrutiny have played out in this political context, and those lawyer issues really were what forced the Obama administration's hand to take sides. And this distinction between heightened scrutiny and rational basis scrutiny is continuing as we see all of these cases to be litigated. The lawyers keep arguing for heightened scrutiny and make the arguments I just said, that it's sort of a no-brainer, that if you ever sat down and just looked at the question whether it should be presumptively constitutional or presumptively unconstitutional to discriminate against people just because of their sexual orientation, the answer is pretty easy. The courts keep saying, you may be right, but I'm not going there. I don't need that. Rational basis is just good enough for me. And so we saw that in the Ninth Circuit in the Perry case. We saw that in the First Circuit in Judge Boudin's opinion in the First Circuit. And so they're really saying, Lawrence and heightened scrutiny and everything, that's okay. But I'm going to talk about Romer versus Evans, which is the case in which Justice Kennedy held state law unconstitutional under rational basis scrutiny. And part of that is trying to appeal to Justice Kennedy. But the central reason is, once you say there's heightened scrutiny, you're not dealing with a single low dive kind of case anymore. You have essentially held that all states have to marry same-sex couples, because there's no conceivable way you could justify discrimination in marriage rights if you really took it seriously and had to have real justifications, substantial or compelling justifications, narrowly tailored, the kind of scrutiny that really applies to suspect classifications. And so that's why the courts are keeping their heads down and saying, well, we agree, we'll hold this unconstitutional, but it's rational basis. And I would expect that you're going to see the exact same move in the Supreme Court in the DOMA case or the Perry case, whichever one they may decide to take next year.
So I think this segues nicely into, I know Suzanne Goldberg has some thoughts on the defendant interveners in these cases. So maybe we'll let you wrap that up, and then we'll ask some bigger questions.
Sure, and I will do this with a promise to stay out of the wonky weeds on this. So I'm going to just make one basic point about what's happening in these cases. Once the Obama administration decided to stand down in the DOMA cases, and likewise, once the California Attorney General, Governor, decided to stand down in the Prop 8 case, the question was, well, what happens next, right? When DOMA is struck down and when Prop 8 is struck down, who is going to be appealing to the next level of court? And that's a question that has been decided in all of these cases, but so who gets to appeal? So obviously, as you know, in addition to the presence of the government defendants in these cases, in the Perry case, there is protectmarriage.com, which intervened to defend Prop 8, as well as some other individuals. And in the Defense of Marriage Act cases, as Paul just said, the bipartisan legal advisory. I know that it's not an action group, that's probably too sort of activist-oriented. The bipartisan legal advisory group, which of the House, which is, I think, 5 members of the House, although maybe I'm getting, yes, that's right. So they're the active defendants in the case, right? Not the government. And so the question becomes, can a non-government body really appeal the striking down of a statute, of a federal statute or of a state constitutional amendment on its own? And it's kind of a weird thing, because when you think about enforcing a law, why the plaintiffs have gone to court, right? They've gone to court to get an injunction against the government from enforcing the law. If the plaintiffs win these cases, challenges to DOMA and Prop 8, enjoining protectmarriage.com and the bipartisan legal advisory group won't do anything to limit enforcement. And when you have the government in both of these cases saying, well, we stand down, right? We would accept an injunction against us, it becomes a very interesting and important question about whether these interveners actually have standing to take the cases up. Complicated for a variety of wonky weed reasons that I won't go into here, but I just want to put it on all of your radar screens to think about, and if you would like to go deeper into those weeds at some point, at some future time, I would be happy to talk about them.
Suzanne, isn't the Justice Department, at least in the DOMA side, solving that by filing their own notices of appeal and their own cert petitions?
Well, I think it's an interesting question, because the Justice Department got the result it wanted, right? Because it said, we want this, we agree that DOMA in our analysis is unconstitutional, so can you appeal a decision that essentially you asked for?
I want to ask just a couple general questions before we take audience questions, and one of them goes to this. I sort of feel like interwoven through almost everyone's comments was this. Just simply noticing that the world has changed profoundly in a very, very short amount of time. We haven't seen the needle move on abortion this way. We haven't seen the needle move on voting rights or other hot-button issues. But on this, there's been just a sea change in an incredibly short amount of time. And, Professor Carpenter, you started us off by talking about Lawrence and the trends that we were seeing. And I think there's an interesting problem here of what trend we're counting. So we can certainly say, going to Stacy's point, that the polling is changing and demographics are changing and that the sensibility is changing. But certainly every time this goes to a referendum in a state, the trends are not holding that way at all. So I wonder if any of you wants to respond, either using diving board analogies or weeds, but just respond to the question of, I'm not sure anymore what we're counting. And I know it inflects on the question of what entity we want to decide this, whether it should be happening by referendum or by legislature or in the courts. But just help me understand what it is what are the trends that matter?
Well, we have had 30, or maybe it's 31, I lose count of these constitutional amendments at the state level that limit the granting of marriage to or exclude same-sex couples from marriage. That must count for a lot if you're a Supreme Court justice and you're looking at the impact of a decision that you might make and how much it might be resisted. I think it is worth saying, however, that the change of opinion on this issue has been startlingly fast. And so that many of those votes were held back in 2004, which is now almost an epoch ago, it seems, in the development of this issue. And the votes have been getting closer and closer and closer, with the unfortunate exception of North Carolina recently. And I think we're going to have 4 pretty close votes when we come to November. I think Minnesota, for example, has a very good shot at beating the amendment that's on the ballot for a number of reasons. But we've learned from the campaigns in the past. There have been enough defeats that you do learn from these things over time. Public opinion polls do seem to be moving in the direction of same-sex marriage. And what's two things to me are notable about that. One of them is that the direction has been almost entirely for more acceptance of same-sex marriage. It's been generational. And unlike on other issues, voters, young voters, don't seem to grow more conservative on the issue as they age. They don't seem to revert back to an older view that when they go out and start families and go out to work, as they might on property rights or taxes or what have you, or drugs. They don't have that. They don't have that view on marriage. It seems to be a one-way ratchet, which I think is a very encouraging thing. So that the trend lines seem to me certainly to be in the right direction. But the caveat to this is, if we're not successful in the Perry litigation, in having the court strike down the state marriage laws, then we are faced with a very brute political fact, and that is that we have 31 state constitutional amendments that have to be confronted. And so one possible scenario post a Perry loss is that we are going to go through state by state through this arduous process that is going to last potentially a lot longer than anybody, a lot of people I know at least, think it's going to last today. It's very hard to undo constitutional amendments at the ballot box. The other side on these fights has in the past been more disciplined about voting. The kinds of people who oppose same-sex marriage are much more faithful about voting. They tend to be older voters, for example, who do go and vote. Younger voters don't as much. That is a very stark reality facing us, potentially, in a post-Perry world.
What's really interesting about those public opinion polls, as Dale said, is it's not like one of these issues where it's going to level off at 53% and be in that little gap between the Romney vote that's solid and the Obama vote that's solid. It is continuing to go up at like a 45-degree angle, and it's about 55% now. And so what you really are seeing is it's going to be an overwhelming majority position comparable to the one that's the 80% that support laws barring discrimination based on sexual orientation and employment. But of course, we don't have that either at the federal level or in most states. So there's a real disconnect between public opinion and the ability to get these things done. And a lot of it has to do with single-issue voters and activists who are very, very effective on the other side.
Stacey, do you want to weigh in on how it is that this changed so quickly? I mean, do you have, you know, it sounded like you were saying this is about conversations at the water cooler. And I wonder, for folks who think about other issues, what happened that was right to get people to, you know, have this dramatic uptick in approval in just such a short amount of time?
Yeah, sure. Originally, I was thinking about this in terms of Malcolm Gladwell's tipping point theory. And I was trying to map out, okay, so who is the maven and who is the persuader, and whatever that template is that he uses, the theory. But I think that it has been just the nexus of interest. It's the generational piece. It's the high-profile support, a number of celebrities who've come out so that people can actually set their eyeballs on a person that is LGBT. And I think that there's this normalization that's occurred. So New York was a huge lift, a huge boost for us in terms of sheer numbers, but as well as just the visibility and the continued pushing forward of the dialogue and the discourse. So to the extent that we can continue to engage people over the course of the next election, I actually, we've been launching a Career the Vote campaign. That's a public education campaign to encourage voter registration and to talk about the issues. So we'll certainly be using that campaign as a mechanism for getting the correct information out and continuing to, as I said earlier, change the hearts and minds of people who are actually going to be casting votes. The actual door-knocking campaign, block by block, polling and asking questions, and really, for some people, just planting even the seed, the thought, because people, if we keep in mind, very few of us have the privilege of sitting in a room having this conversation that we're having today. So people are, particularly in these economic times, trying to focus on keeping their families intact. So the last thing they want to hear about is another person's family. Like, really, I just want to put food on my table and make sure that my kids are safe and that they have a quality education. I don't have time to think about what other people don't have. So it is somewhat remarkable that even in these times, in this context, in these retracted economic times, that people do have the capacity to even engage on this issue. And it's because I think that people really don't appreciate discrimination. You mentioned that it's over 80-something% for the employment rights. Now, true, we don't have in the past yet.
We should have.
But interestingly enough, the hearing that was held earlier this week, if you think about the optics of that hearing, I don't know how many of you in the room watched the hearing, but for the first time, the Senate hearing included a trans person on the hearings, on the witness panel, and the person that provided testimony was Kyler Broadus, who's an African-American transgender man. And from what I understand, the Senate committee members really leaned in and listened, and I'm not saying that they don't typically pay attention and listen. I'm not saying that at all on camera. What I'm saying is that that optics matter, that people really do appreciate sort of a fresh face, a fresh perspective, and that even the members of Congress who are inundated with issues and meetings, et cetera, really found this fascinating, this notion of employment rights for transgender people. So if we're able to do that, as well as have a high-level corporate representative of a major company who happens to also be a person of color talking about these issues, I think that that helps to bring larger interests into the fold, and that there's a ripple effect. I really do believe that that's what's partly attributable to that change we're seeing.
So Suzanne, you can either respond to the kind of broad question about what's changed. I know you also have some thoughts on the international piece here, so maybe you can do a high dive and a low dive at the same time. And
jam them all in. What's it called, like a double pike twist thing? Okay, yeah, great. So I actually want to follow right up on what Stacy was saying and just make a couple of quick points. And the first is to share an experience that I had in the early 90s when I was working on a lot of the anti-gay initiative litigation, like the one that gave in Colorado that gave rise to Romer versus Evans. But I remember being here in Washington at a focus group, and there was we were getting reports back on the kind of messaging that worked in terms of persuading voters to vote against anti-gay initiatives. And the person who's a terrific, very well-known polling person was talking about all of these messages. But finally, I raised my hand and I said, well, because she never mentioned equality. And I said, well, what about equality? And she said, equality is a message that resonates with law students and lawyers. And it actually isn't the message that resonates generally with the public, who have so many more things to be thinking about. And I guess what I would also say in connection with that is I think, like, I love the law. A lot of us here love the law. But the law is not the thing that necessarily moves the culture. And I think this goes back to what Stacy was saying about the popular culture. Lady Gaga moves the popular culture. Other people, as much as we all might have to say, right, other people are moving the culture more. And it does seem to me, for better or worse, and so it seems to me that that is a very significant part of the needle shift And then when you hear the statistics, which I've heard, I haven't studied, but I'm going to assume are true, that more young people vote in American Idol elections than in presidential elections, it reinforces for us the importance of popular culture in shifting views on gay rights issues, on an assortment of gay rights issues. And that, for me, reinforces in turn part of why the needle will stick and keep changing, because the people who are voting in American Idol are also becoming the next generation of teachers and the next generation of educators, and again, that is for better or worse. But the bottom line point with respect to the issue that we're talking about here, equality for recognition for same-sex couples, is that that is for better, because there is just a fundamental shift, and I think it's not about equality so much as about fairness and about this is not, sexual orientation distinctions are just not nearly so salient, interesting as they might have been to society 20 years ago. So we're, which is also not to say it's not still tight on these issues. I mean, certainly we lost in North Carolina, and we will no doubt lose elsewhere, but it is to say the shift is significant. And one last piece I want to put in the mix is where we sit internationally, right? So where do we sit? We sit between Canada and Mexico, both of which recognize marriage rights for same-sex couples. In fact, 11 countries in the world currently recognize marriage, including countries that are politically far more conservative on some dimensions than ours. And this is really all, on almost every continent, there's marriage recognition for same-sex couples. And then if you add to that some other form of legal recognition for same-sex couples, something civil union or domestic partnership like, the number, I forget if it doubles or triples, but it's very significant. So again, this is an area in which we are not leading by a long stretch, and recognizing that, of course, the international data will not be most compelling to the U.S. Supreme Court, most likely, or at least some of the justices, when these issues go forward. I think it's still very important to remember that it's not like we're really on the cutting edge here. And even Massachusetts in 2003, when the Supreme Judicial Court recognized marriage rights for same-sex couples, it was breaking new ground in the United States. It was not breaking new ground in the world.
I think I want to open this up to questions. So there are people with microphones, is that correct? So there are people with microphones, and I'm going to urge you to wait until you get a microphone, because this is being recorded, and I'm going to urge you to ask a question as part of your question. And I can't see all that well, so maybe right over there? Yep.
I have a question about, we've been talking a lot about DOMA and striking down Section 3, excuse me, and the likelihood is the court will not do a sweeping act and strike down the entire statute. Given the ability of Congress through the Constitution to regulate the full faith and credit clause, do you see any court challenges to Section 2, and if not, what do you see the next steps beyond just the Respect for Marriage Act of overturning that part of the law?
I don't know. It's not clear. The law is a little vague at this point. It's not clear that Section 2 of DOMA really changes the law at all over what the power the states already had under the full faith and credit clause to not recognize other states' marriages when they were inconsistent with their public policy. So no one has really focused on challenging that piece of it because it's not clear that it makes that much difference. There's a long history in this country of states not recognizing other states' marriages for policy reasons. Now, of course, if states start doing that in the future, there will be equal protection challenges. And so, once we hopefully get Section 3 struck down and states are refusing to recognize marriages, there will be cases filed all over the place. It's going to be like a brush fire, but they will primarily be that even when you're exercising your public policy power, you have to do it consistent with the 14th Amendment. And the arguments will have to be, what is your interest in not recognizing this marriage? And morality isn't it after Lawrence. And so, you have to sort of, this will be done step by step. I don't think there will be a facial attack on that section of DOMA that will solve anybody's problems. That would be done kind of state by state as, maybe eventually it'll percolate back up to the Supreme Court as a 14th Amendment case. If that helps.
There will also, I would think there will also be litigation. It's assuming DOMA is struck down. I would assume there will also be some fighting with a potential Romney administration over how to administer federal law after this. I would expect a few brush fires there too.
That could be interesting.
Yeah, go ahead. He's coming. He's coming. He's coming.
Speak right into the microphone.
You got it.
Thank you. I would like to, this is a question. I ask it as one who never liked the Perry lawsuit, never thought it was wise. Now, I'd like to, each panelist, and Dahlia also, to tell me, us, what you thought of it when it was filed and how your view of it has evolved, if it has.
Does anyone want to?
I think he asked you first.
I think he asked you and then me. You know, I mean, it was clear, and I think we've heard today that Perry wasn't part of, you know, Perry was kind of came out of the ether, and you know, what was, I thought that Judge Walker's decision in Perry was a soul-stirring piece of poetry. I mean, I thought it was really a great thing, and I think that the court wasn't ready for it. And so I guess, you know, I sort of have to double down on what Suzanne and Paul have said, which is I think that it was in Dale's words, too much too soon.
So I'll just add briefly that I think for me, you know, what I think of Perry depends on how I look at it, right? In the sense that, you know, has it been a good thing culturally, politically, that Ted Olson and David Boies,
Yeah.
I don't know why and David Boies teamed up to bring this case and raise the profile of marriage equality issues in a whole set of circles where these issues hadn't been talked about, or at least hadn't been talked about as positively as they are now? Absolutely, right? That's a great thing. Might I have preferred that they raise the profile through an amicus brief rather than a new litigation? You know, taking into account some of the risks associated potentially with the litigation that they pursued? Yes. Do I think that you know, a lot of great work was done in that litigation to produce some great opinions? Also, yes. I think probably, you know, there will be just more, you know, to bring in another sports analogy from someone who's not so sports-oriented like myself, but some, you know, more additional Monday morning quarterbacking about whether the Perry case was a good or bad thing, depending on what happens at the U.S. Supreme Court. Absolutely. I mean, the bottom line thing I will say about it is it is a very, very high stakes case. And typically, the GLBT legal advocacy groups, as with many law reform groups, have thought very carefully and based on history and experience have moved more incrementally for many of the reasons we've been talking about.
Does anyone want to add, or? Okay.
I would just say, the one thing I would say, I obviously was very much on the incremental side of this divide back in 2009. And indeed, as Ted has said, he offered me the job before David. So, and at the time, I wasn't sure there were 4 votes. But even the 3 years we've lived through, the amount of progress we've made, the amazing vote in New York, which in many ways might be attributed to Ted Olson having stood up as a Republican conservative, you know, makes me reasonably hopeful that we'd get 5 votes. You know, I still think it probably would have been smarter to wait until we might get 7 votes, but I'm pretty hopeful that Justice Kennedy doesn't want to go down in history as having voted down that claim if it doesn't get deferred. It might well. They might well take a DOMA case, hold on to the Perry case, remand it for some more consideration. You know, it could be several years before we actually get a vote in that case, at least under some scenarios.
Yeah.
So I largely agree with what Paul and Suzanne have said. I thought it was too soon when it was filed in 2009. I haven't changed that view today. I think my view about how it's likely to come out ebbs and flows depending on which Perry result we think we might get. And there are a range of them, from extremely narrow opinion to a very broad opinion. I think there's much not much reason to believe the Supreme Court's going to issue a Walker-style opinion. But there are narrower choices for the court than that. There is the Reinhardt version on the other end, and then there's some intermediate choices calling into question state constitutional amendments, or if you grant civil union status, you can't deny the dignitary interests in marriage or something like that. So there are a number of different, a range of possible decisions. It seems to me the likelihood decreases as the breadth of the ruling increases. I also, there are the results of a loss in Perry. One hopes that it's a narrow loss and that the court leaves open lots of issues for future consideration and doesn't deal broadly with the issues that could be presented in the case, because the court's not limited to what Judge Reinhardt said. I mean, the court can deal with other issues. But they're legal. There could be morale implications. There could be political implications. Bowers versus Hardwick was not simply a loss on sodomy laws. Bowers versus Hardwick was a loss across a wide range of domains in the law and had effects for a generation. I don't think that the Supreme Court's going to issue a decision that's quite that dismissive of gay rights and quite that harsh. It seems to me it's potentially more than just not striking down Prop 8.
I'll just say that I haven't heard anything that my esteemed colleagues have said that I disagree with. I could have sidestepped it and just said we're not a legal organization. We are an advocacy organization focusing on legislative advocacy and public policy. There you have it.
It's a good thing you didn't do that. Next question. There's so many here. Go ahead. Yeah.
I have a strategy question that goes a little bit outside of what people have talked about so far. It really has to do with what happened in the Prop 8 trial, where Walker said, okay, well, we're going to actually try these claims about what happens to children. One claim about what happens to children that I never hear people talk about is what happens, but it seems sort of ripe given all the concern about bullying, is what happens to gay children in straight families. I'm a straight person. I have 2 sons. I have no idea what they will end up being when they get to that point in terms of their sexual orientation. But I want them to know that they can have healthy, meaningful, long-term relationships with whoever their life partner turns out to be. And not every gay child grows up in a family that's going to emphasize that. So I'm wondering if there's research out there about the impact on gay children of having, now that there has been same-sex marriage in some states for a while, what happens to them? Does it have a positive impact on their lives in some way?
The professors are over there.
Yeah.
I don't.
Professors?
Suzanne may be aware of. I'm not aware of research in states with marriage and whether that has affected things like bullying or teen suicide rates or mental health or anything. Suzanne, do you know of such studies?
So I guess my short answer is I'm not aware of the studies, but therefore I would base my comments on lack of empirical data and instead on intuition, which is that anytime, I think this is fair to say, probably anytime a state moves toward greater insistence on equality along any dimension, it benefits children because it benefits it endorses, embraces the variety of people and relationships that there might be. And it's interesting to me, and I'll just say on a personal level, that I remember when I went to my first civil union in Vermont, and the officiant stood up and said, by the power vested in me from the state of Vermont, I don't remember, pronounce you in a civil union or something like that. And I was very moved. I got chills. And I think likewise for me, and I'm not the biggest fan of marriage personally, But I'm an absolute fan of equality in marriage rights. But I feel different walking around in New York, knowing that everywhere in the state, same-sex couples can marry. And I wonder and hope it makes a difference for my children. But the last thing I'll say is when I think that, then my next thought is often, I wonder how many people even really know.
Yeah. I will say that when you debate Maggie Gallagher on this issue, she will say repeatedly that there is no evidence that it's helped in any way with kids, and I'm not sure what she bases that on. And my intuition is the same as Suzanne's, that it would be a beneficial thing, but I'm not aware of actual studies yet.
Ian? Wait for a mic. Sorry.
So I want to ask about an intrusion of a weird kind of federalism into this space. Judge Bodine wrote what I thought was an excellent opinion saying that DOMA is discriminatory, and then having written this excellent opinion, he then slaps on these weird few pages, and I think the key line there is he said that there's a thumb on the scale against DOMA because it, quote, burdens the choice of states like Massachusetts to regulate the rules and incidents of marriage. Now, that's not just wrong, but it's wrong in the exact same way that Paul Clement's argument against the Medicaid expansion in the ACA is wrong. The suggestion that federal tax policy somehow, because that might change the behavior of state, attains some sort of constitutional suspectness. And so my question is, both what is the legal implications of this for other areas of law if this line of reasoning is picked up, but also what are the political implications? Because, I'm a supporter of marriage equality, but the price of equality should not be Medicaid, and I don't want to see a wedge driven between the communities that depend on one and the communities that want the other.
I know, the professors are on that side.
Well, the argument that we made in the briefs in Gill was that interest regarding the welfare of children or morality or tradition and all of that stuff are not interests that should have much, if any, weight in upholding Section 3 of DOMA, because the federal government isn't supposed to have a view about domestic relations policy and what's the best setting in which to raise children. That under our Constitution, as the Supreme Court has said many times, that's an area reserved for the state's domestic relations law, and that therefore in the equal protection calculus, they ought to either be required to just talk about interests that relate to the federal government, such as saving money, or at least these other arguments ought to be given much less weight, or you ought to look at the equal protection analysis a little bit differently. What Judge Boudin said is that was part of his reasoning for giving heightened rational basis scrutiny, and that this was kind of a peculiar burden on the state's ability to exercise its original power to regulate domestic relations. You could debate about exactly how it was phrased, but I don't think that this peculiar law, which does very odd things, and the analysis of it, however it comes out of the Supreme Court, is going to have any major impact on the ability of Congress under the spending clause to set all sorts of other criteria on how things are spent. So I don't see it as a big concern. If it was a 10th Amendment decision, there might be a different thing. But they did not accept the 10th Amendment argument that the state made.
I was going to say.
Go ahead.
Yeah, I mean, this portion of the opinion seems to me like another one of these Dear Justice Kennedy passages, because it does appeal to a theme in Justice Kennedy's work about federalism and allowing the states to go their own way on certain issues. So in a sense, I can see it as a strategic move. I read the two sections of the opinion to work in conjunction and not to be independently a basis for questioning a statute. It's the fact that the federal government was acting in the way that it did in an area of special sensitivity of traditional state control that made it problematic. That may or may not be the case with other laws, whether it's a Medicare law or what have you. I think what Boudin was trying to do was stand by a tradition of federalism in marriage without questioning the tradition of marriage. I mean, that's ultimately what I think he's trying to do. And his opinion suggests actually hostility to the idea that there's a constitutional right to same-sex marriage, a la Judge Walker and the Perry litigation.
The only thing that I want to add is that I think the line is a great one rhetorically, right? When you look at the popular debate and and make the point that, well, we do allow states to do what we do. I agree with both Paul and Dale. I don't think that that line will have any significant implications beyond this particular kind of case. And I suspect you could find similar lines in a variety of opinions that would likewise have the potential, if read broadly, to rearrange the relationships between the states and the federal government that wouldn't be read that broadly because they are really particular to the context in which these cases are decided. And I think it's also, I mentioned this for the law students in the room, it's very interesting to read opinions with keeping in mind that judges who are writing the opinions are writing not only for lawyers and for lower courts, but also for the media who has to digest the opinions, who are often not lawyers, and have to then offer up some account of what's being said. And I actually read that line to be sort of fitting into the popular conversation more than to be making a big point about doctrine.
I would have been much more, just one last thing, I would have been much more concerned about Judge Toro's opinion and the 10th Amendment opinion that he issued.
There's a massive hands back there, but I actually can't see. So I'm going to say whoever's closest to the mic. Yeah.
My question is also about strategy. I'm curious why, well, if striking down DOMA is necessary before there could be a success with Perry, and why that might be the case. And the reason I ask is, as a law student in North Carolina, and observing the campaign against Amendment 1, I felt like a lot of the campaign was focused around how this was everyone's issue. And it wasn't focused around equality, it wasn't focused around discrimination, it was focused on how passing Amendment 1 would affect everybody, which didn't seem to be bringing the real issue to the forefront and having an honest conversation about what this was actually about. I see, that's a political issue, state-level political issue, but I see Perry as the, I'm sorry, DOMA as the, as you were saying, the low dive, the same way that, this kind of campaign at a political level, state level, was also kind of a low dive approach, and it failed. So I'm wondering, when we're looking at, back to the question, why is it that we can't just go for the high dive right now? And how long would it take to get there?
Can I just jump in really quick? First of all, I want to say, it's horrible to live through one of these kinds of experiences. I think that is data that we do have, right? That it is very damaging for people who live in communities where one of these initiatives takes place. It's damaging for the adults, and it is damaging for the kids. Quite brutalizing, and the after effects last for a long time. Second point, I think the message about the North Carolina amendment affecting everyone is grounded and has some real power to it. And I think, for a variety of reasons, when I don't think we have time or need to have that discussion right now, but I think there can be value in that message. I do think a lot of messages wind up being crafted in these campaigns from polling rather than from what we might think, in this room are necessarily the best messages. But I guess the other point I wanted to make is it's not that we have to win the DOMA cases to win Perry, right? They're not necessary, like one is not a condition precedent to the other. One is not necessary for the other. I think the point is just doctrinally and politically, it is a smaller move to strike down the federal government's rule that says we won't recognize states' marriages than to have a court say, all states, you must recognize these kinds of marriages. And it's not, and the core point is, of course, the right one, right? Of course the states should recognize the marriages of same-sex couples, but the question is, have the doctrinal and other foundations been solidified enough to make us confident that we could get that kind of decision from the highest court?
You know, your question kind of reflects, I think, what's been a very interesting phenomenon in the last 3 or 4 years in the movement, which is this emergence of this great divide between the old guard incrementalist groups that have been litigating and lobbying on these issues, and this emerging, largely generational group that says, these questions are really dumb and easy. Why don't we just tell everybody they should stop discriminating, and maybe they'll stop discriminating? And, you know, I really understand that urge, and I think that the fact that, you know, both such groups are out there fighting is really part of the strength of the movement. But there is also obviously division, and what you've seen is that division ultimately reflected, at least in the beginnings of the Perry case. Now, maybe it has gradually become an incrementalist piece of litigation as it's gone up through the courts, and the Ted and David have made these narrower arguments, and Judge Reinhardt obviously found them to be a persuasive way to think about the case. But it seems to me that, at least in legal things, for the reasons Suzanne was saying, it's often better to keep your eye on the one step at a time, and not just make your decisions about why can't we just go for the home run all the time. It's just not necessarily the right way, because if you look at the history of what Bowers did, and you know, those of us who were around and remember that, it was a terrible 17 years of trying to fix that problem, where it was a complete barrier to any progress. And so, I mean, at least maybe everybody your age would say, well, we're all just haunted by history, Vietnam and Bowers versus Hardwick, you know. But there is that history.
So I don't think that a win on the DOMA case is a necessary precondition for a win on full marriage rights later on in the courts. But a win on the DOMA case, while bracketing the larger issue of a constitutional right to marriage, a win on the DOMA case does help, because it brings into sharper relief, I think, the inequities and insanities of not recognizing same-sex marriages. So it may be true. Let's say DOMA is struck down on whatever grounds the Supreme Court chooses. Let's say that happens. Then we get a split double header. You know, the court takes Perry and DOMA and strikes down DOMA and upholds the California proposition, something like that. It's true, as I think Paul said earlier, that states may not have to recognize same-sex marriages from Massachusetts when, say, a couple moves to Mississippi. But if the federal government has started giving federal benefits to that couple in Massachusetts because they live in a state where their marriage is recognized, all kinds of benefits will be available to them, joint taxes and everything else. Then what happens when they move to Mississippi? The state, I guess, doesn't have to recognize their marriage for state purposes, but will they be recognized for federal purposes? Will they continue to be recognized for the federal purposes? Or will those benefits be withdrawn from them as well? Those are the kinds of issues that will come up. And I think those will really call into question the viability of continuing to refuse to recognize same-sex marriages around the country.
We have time for one more question, and yeah. Right here, sorry. Oh, I'm sorry.
I guess from a historical point of view, I just had a question for many of you who were in the very beginnings of this fight. Was there ever any discussion on attacking it as discrimination based on gender, which would automatically get you to the heightened scrutiny? Mark?
Well, that was certainly an argument made back in the very first marriage case, which was the Hawaii case, and it actually was accepted by the courts. And it's an argument that people have thought about making along the way. We thought about making it in Lawrence. In the end of the day, I think the general view has been ultimately that's not really what these cases are about, and that it seems like more of a device than a real description of what the nature of the discrimination is. And so, in the end of the day, these arguments have been tried, but I don't think they're being tried very much anymore. Is that right?
Yeah, and there are two versions of the sexual orientation and sex discrimination argument. One is you can marry a man but not a woman if you're a woman, and that is on its face sex discrimination. The second one, which, and a lot of people think, yeah, true, but it's not compelling. The second one, which I think is compelling but not necessarily a litigation winner, is that drawing lines based on sex not to sound too academic here, but it really does police gender roles, right? And it involves the state in policing gender roles. Now, I find that to be quite compelling, but I think to a court, in discussion and in academic settings, but I think to a court it's just not as persuasive given the doctrine that we have. At the same time, I think it's an argument that is sometimes made and can usefully be made in a sort of expressive way, right? In an atmospheric way. It lets you tell a different story about some of the harms that are caused by the sex divide in marriage laws. But is it the argument that's likely to pave the path to victory? You know, as Paul said, like, we've seen it and it's been made, but it has generally been an argument that at the end of the day, in any litigation after appeals have been made, is not the argument that these cases have
That said,
been
though, interestingly, there's a very strong movement just in the last few months toward treating discrimination against transgendered people as gender discrimination. And there was a great decision from the 11th Circuit where a woman was fired for transitioning from the legislature of Georgia and held to violate the Constitution, but whole analysis in there about how this would also violate Title VII, and then the EEOC has followed up with a regulation saying that it is gender discrimination to fire people because they have changed their gender, which makes a lot of sense if you think about it. And so this has actually been a very interesting development in that area.
So I think we're out of time, and I want to thank Stacy and Paul and Suzanne and Dale. I want to thank ACS for putting this together. I'm going to read you an obligatory statement. Hold on. It says, at the end of this session, there is a networking luncheon followed by Perspectives on Federalism, a conversation featuring U.S. Court of Appeals Ninth Circuit Judges Alex Kaczynski and Stephen Reinhart, moderated by UCLA law professor Adam Winkler at 1:00 p.m. in the Presidential Ballroom. And later this evening, there will be remarks by U.S. Supreme Court Justice Ruth Bader Ginsburg at 6 p.m. in the Presidential Ballroom. I want to thank you all for your patience with us and your time today, and I hope you enjoy the rest of the weekend. Thank you.
Great. I'm so glad you were here.